You followed your chartered accountant's advice, signed the documents, filed your taxes, and now the enforcement directorate is knocking, alleging money laundering. How is this even fair? Hello, this is Dr. Arjun Chowdhury, advocate, and I welcome you all to this new episode of the White Collar Crime Legal Series. In this video, we will address one of the most commonly misunderstood issues under the PMLA. Can you be arrested under the PMLA even if you acted entirely on professional advice from your CA or lawyer? Let's be clear. Taking advice from a chartered accountant or a lawyer is a good practice, but it's not a legal immunity. Why? Under Section 3 of the PMLA, money laundering involves directly or indirectly attempting to indulge in, knowingly assisting, or knowingly being a party to the laundering of proceeds of crime. Now ask yourself, did your CA verify the source of funds? Was the predicate offense disclosed to them? Did you disclose everything honestly? Because ED looks at actual knowledge and intent, not just whether you consulted someone. So if the transaction involved criminal proceeds, even unknowingly, you can still be booked under the PMLA. This is what we call the mens rea, trap. The focus is on whether you should have known. So the question is CS advice a defense in law? Yes, but only as a mitigating factor. If you relied on a CS written advice in good faith without knowledge of criminality, courts may accept that there was no intent to launder money. Consider it during the bail hearings, discharge applications, or even sentencing. But be aware, advice must be documented. Courts do not accept oral claims of advice unless there is clear evidence. Now let's understand the legal remedies available to you if you are facing ED scrutiny despite following professional advice. Here are the steps you must take. Gather documentary proof. All emails, memos, signed notes, WhatsApp chats with your CA or lawyer, even the board resolutions, transaction reports, compliance certificates. This shows due diligence and lack of intent. You must engage a criminal lawyer at the first hint of ED action. Do not wait for summons or arrest. Your lawyer can help preemptively file anticipatory bail application. You can also file a petition for quashing of the FIR or ECIR if there is no direct link to the predicate offense. You may challenge the necessity of arrest. As per Supreme Court's latest judgment in Pankaj Bansal versus Union of India and also the Vijay Madan Lal Chaudhary's judgment, arrest must not be routine. ED must show the need for custodial interrogation. If you have cooperated and the evidence is documentary, custodial arrest may be challenged before the court. Finally, do use professional advice as defense during trial. At trial stage, your legal team can argue absence of mens rea, show you have acted reasonably and prudently, introduce your CA or the legal expert as a defense witness. Now the main question is how to avoid ED trouble despite having professional advice. Here are the compliance habits every entrepreneur and professional should follow. Always demand transparency from your advisors. Ask where the money is coming from. Is there a predicate offense possibility? Will this stand the scrutiny under the PMLA? Insist on written opinions, even if brief. Maintain audit trails for high value or offshore transactions. Avoid proxy arrangements or dummy entities. These are the red flags for the ED. So good faith is not enough. You need a legal strategy. Following your CA's advice is the right thing to do. But PMLA is a strict law and courts look at substance over form. If ED action is triggered, don't panic. Don't be silent. Take immediate strategic legal steps, and if you are in this situation or want to prevent it, speak to a criminal law expert as soon as possible. Your freedom and reputation may depend on it. So I hope this video has empowered you with real actionable and legal insights. This is Dr. Arjun Chowdhury signing off. Until next time, stay informed, stay compliant, and stay protected. Jai Hind.